You are listening to Zimbabwe News. Keep listening to Zimbabwe News.
Yes, grounds of appeal. There is no any matter that you'll find that will not have grounds of appeal. But there is something unique about this case which is before us today, whereby the High Court only remains the court of inherent jurisdiction, which has powers to look into the current matter. All the Supreme Court judges and all Constitutional Court judges are part and parcel of this litigation. They are respondents to the matter. Generally, the rule of procedure is that if you are not satisfied by a judgment delivered in a lower court, for example, in this case, where the respondents were not happy about the judgment of the High Court, the process is that they will appeal to the Supreme Court. And the Supreme Court judges are those who will be supposed to deliberate on the grounds of appeal that have been advanced by the aggrieved party. But in the circumstances, it is difficult for the Supreme Court judges to preside over the matter which they have been respondents, where the Supreme Court judges are also part of the people who are involved in this litigation. So the main question which many people will be asking is, to whom is the appeal going to be heard? And the most difficult thing is that there is no any provision in our law at the present moment that can explain the current lacuna, where we don't have the way of how to deal with this matter. However, others are suggesting that Emmerson Mnangagwa would promote some High Court judges to become Supreme Court judges, and then he will ask those appointed judges to hear the appeal, which in essence will give him the only alternative route for him to negotiate the current problem which the government is confronted with. Others are saying that he can appoint retired judges. But that provision, I tried to check it both in the Constitution and also in terms of our rules of the Supreme Court and also rules of the High Court. I failed to locate where it says that if all Supreme Court and Constitutional Court judges are handicapped for them to hear an appeal from the High Court, the president may appoint retired judges for them to hear that appeal. It is not provided anyway in our laws. So I wonder how those people who have appealed, how they want to prosecute their appeal. We are waiting to see whether Mnangagwa is going to promote some judges he is going to pick from the High Court to the Supreme Court for them to hear this appeal, or what will happen. There is still a lacuna to explain how this appeal is going to be prosecuted. And as we understand, and also the explanations that we are getting from the Zanu-PF people, is that they have noted an appeal, and generally an appeal suspends the judgment of the court. So, something that I doubt very much, because in as far as the the legal practitioners of the applicants of the previous matter. They are saying that the Supreme Court and Constitutional Court judges did not file affidavits opposing the application that was before the High Court. Only the Ministry of Justice and the Judicial Service Commission, who were part of the respondents in the matter, are the only ones that responded. So the judges did not, in their individual capacity, filed affidavits to oppose the application that was before the High Court. And the rules are very clear. If you did not file an opposing affidavit, where will you get the grounds for you to appeal? Because there is no issues you brought before the High Court when your matter was being heard. So we wonder how the Zanu-PF government wants to deal with this, except if they are going to engage in mafia style or mafia legal processes. That's when we will see some jokes which they will try to purport as an appeal. But basically, at the present moment, we don't have judges in the Supreme Court and in the Constitutional Court who can hear this matter, as they are all interested parties in the outcome of the appeal.
Right. Honorable Job Sikhala, thank you very much. I believe you have concluded your rendition tonight. Honorable Sikhala, I believe you have concluded.
Yes, I've concluded, Simba.
Okay, thank you very much. Well, this is Honorable Job Sikhala. If you're coming in there late here, press the share button. Right, to those who would like to watch this program, to share this program for people to watch it, just press the share button. And you can just share that link into WhatsApp and all other networks. And that way, people can and will be able to follow it. Okay, so now we're going to move to Dr. Masimba Mavaza, and we'll have him have his 2 minutes. Dr. Mavaza, over to you.
Exactly 1643 today in Zimbabwe, which was 1443 this in England, the respondents, that is the Ministry of Justice and Legal and Parliamentary Affairs, plus 18 other respondents, lodged an appeal, a notice of appeal with the Supreme Court. The fact which my learned friend and colleague, Honorable Sikhala, is failing to understand is the fact that an appeal can be lodged whether the court is in sitting or not. It can be launched, and when the appeal is launched, what then happens is the administrators of the Supreme Court will then allocate the appeal to the judges who are able to deal with this matter. Now, Comrade Sikhala had probably missed the when he was reading the point that the president or the chief justice or the acting chief justice, for that matter, is a duty or is a right to appoint retired judges to sit in the Constitutional Court. Yes, I agree with him that it does not say when all the judges are incapacitated, because the law did not foresee a situation like this one, which was strictly planned by those who had planned it to create such a confusion. The law had only hoped where there could be probably a shortage of 2, 3, or 4. So that's why the words were left out deliberately to say when the whole court is incapacitated. In other words, unless there was going to be an earthquake, which is rare in Zimbabwe, or a nuclear bomb, which is possible in these days, but the law, when the law covered that situation, it covered only in a situation where there are no judges. Whether there are not all judges or one judge or 2 judges, the fact that judges are not there, there could be, there will be, and there will be an appointment of reappointment of retired judges, number one, or elevation of the judges of the High Court into the Court of Appeal, that is the Supreme Court, or into the Constitutional Court. But however, yes, I agree with Honorable Sikhala that indeed in every application there are grounds of appeal. But what matters is, are the grounds, do they hold water or not? The ground could be there, but it could be useless. But in this case, yes, all the grounds have been quite useful. I think, give me an extra minute, I will share with you the grounds of appeal raised today by the government, just to say.
We are okay. I'm sure we're all okay with one extra minute. Please go ahead.
The point number one, the ground of appeal was that the High Court did err or erred in finding that the applicant before it, in particular, first responded, who is the Minister of Justice, had locus standi to obtain the relief that it granted in the absence of evidence of the violation or a potential violation of his right to equal protection and the benefit of the law, as in section 56, subsection 1 of the Constitution. So by so doing, the High Court breached the protected rights of respondent number one, who is the Minister of Justice. And that breach of a right goes straight away to the Constitutional Court. And therefore, that has been done by the High Court, and it becomes an appealable point. Point number two, the High Court further erred in granting the application before it without having made a declaration that in fact the right of the first respondent in terms of section 56(1) of the Constitution of Zimbabwe has been violated. So the High Court did not even consider the rights of the first respondent, and it only went on to make a declaratory a declaration without looking into these facts. So the High Court failed to look into the matter on the round. It just rushed into grabbing the matter, deciding on it, give a decision, and that is an error of law on its own. Again, point number three, the constitutionality of the constitutional amendment number 2 not having been in question, and the High Court having recognized it as a valid law. So the High Court further erred in finding that section 186(4) as amended could not derogate from the provisions of section 328, subsection 7, which I will explain for our readers later what this section say. But of our Constitution, and therefore that second respondent had ceased to be the Chief Justice of Zimbabwe upon attaining the age of 70. So by declaring that he ceased, the High Court had made an error, a constitutional error, because the Constitutional Amendment number 2 is now the law, and it has not been questioned to its own validity. So the High Court, having recognized that the law is there, it was wrong for it then to cease or to stop or to declare that the second respondent is no longer Chief Justice when they have actually accepted that this is now a law. So the law has been followed, and the process of the law was followed. The due process was followed in extending the period or the retiring age of the Chief Justice and others. And again, the High Court further erred in finding that will be point number 4, in finding that the second respondent attained the age of 70 at 000 hours on the 15th of May, 2021, when by virtue of section 336 of the Constitution of Zimbabwe, the second respondent attained the age of 70 at the end of the day on the 15th of May, 2021, not at the beginning of the day. So that is the High Court made an error, therefore, of even removing him from office before he attained the 70, assuming that was to stand. So they cut his office by 1 day, and that cutting of this office is breaching his constitutional right of sitting in that office, and that again is appealable. Again, the High Court consequently erred in failing to find that the appointment of the second respondent as the Chief Justice of Zimbabwe to continue in office it was made by the President of the Republic of Zimbabwe on 11th May 2021. It was with legal effect from the 16th of May 2021. So therefore, it was not effective from the date of him turning 70, but it was with effect from the 16th of May. Right, which will be a day after his 70 years. So the court did not consider that. In that decision, they made it appear as if the judgment or the extension was of the 15th of May. In that, again, that was an error of fact which culminates to the error of law. You see, the High Court further again erred in finding that the current judges of the Supreme Court and the Constitutional Court were not entitled to benefit under Section 186 of the Constitution of Zimbabwe as amended, while at the same time finding that the extension of tenure of judicial service was not a benefit denied to High Court judges. You see, in other words, they're saying the High Court judges could get the benefit, but the other judges above the High Court could not get the same benefit. And by so declaring them, those who were in a superior court, not to benefit from this law, they're simply showing their bias towards their own judges who are in the High Court and against the other judges who are in the Supreme Court. In any case here, let us be frank and honest. Let's stop being political. Let's be honest. Number one, these three judges, when you become a judge of a High Court, you look forward to become the judge president one day. Then you look forward to become the judge of the Supreme Court one day. And you look forward to become the judge of the Constitutional Court. And you look forward to become the Chief Justice. So in other words, these three judges have got vested interest in what happens to the judges of the upper court. Because if they kick them out of office, they are the candidates to fill in those posts. In other words, they cleared their own way, and that is a bias. If you don't call that a bias, I don't understand what it is. So these three judges, or the High Court judges, made an error in assuming jurisdiction of this matter, knowing very well that they stand to benefit from the judgment they will make thereof. In other words, they should have requested other private judges, other judges, retired judges, or foreign judges to be invited and to be sworn in and to sit and hear that application on an urgent basis. But they didn't. So, in other words, they had to create a vacancy in the Supreme Court from the seat of the Chief Justice to the seat of a judge of the Supreme Court for them to fill it. And if you don't call that bias, I don't know what it is. And by the way, this is not contemptuous. It is like a manager firing the owner of the company. What does that mean? It means you want to be the company owner himself. And you don't call that bias, I don't know what you call it. But let me go to point number 7. The High Court erred again in holding that Section 186, subsection 4 of the Constitution could only apply in the future and not the current judges of the Supreme and the Constitutional Court, when there was nothing in the Constitution suspending the operation of Section 186, subsection 4 of the Constitution. So by just making an assumption of the law without reading the law to the letter, the judges made an error of judgment, and therefore their judgment was affected and was contaminated by bias, as we have said, and it becomes an appealable position. And furthermore, the High Court erred in holding that Section 186 of the Constitution is amended, increased a term limit provision. We talked about this yesterday briefly. Section 186 did not increase the term. It simply increased the age limit. So there is a difference between age limit and the term limit. If it was going to increase the term limit, then it was a cause for a referendum. But it was only extending the age limit. In other words, a judge is supposed to be a judge of the Supreme Court or a Chief Justice for 15 years. After 15 years, he has to retire, no question about it. So if you want to make a law to change the 15-year rule to 20-year rule, that goes to a referendum. because and that is where it is said it must not, if it changes, it must not benefit the incumbent. But where a discretion is given upon the head of the state to look at you with the help of the doctors and make an educated opinion and an informed opinion that you are healthy, and then allow you another year or 2 or 5 years, it's between a year to 5 years, to become the Chief Justice. They are not extending your tenure of office, they are extending your age limit. And this is where the mistake was. So therefore, when you look at this, we look at this point, these are the reasons, and these are the points which has been submitted today by 1643 in the Supreme Court. Now, what does this mean? I'll answer my brother Job.